Hello everybody and welcome on back. This is the Gaming Lawyer coming to you live. Well, I guess not live. It's live at the time of the recording, but it's not live at the time of the upload, seeing as I'm recording this early because, well, yeah. Today, as you can probably tell from the gameplay as well as the title, we will be discussing Mortal Kombat. Now, specifically, we are going to be discussing the case Brown v. Entertainment Merchants Association. This case is essentially examining California's attempt at banning the sale of violent video games to minors. Now, California, in its beginning, believed that Mortal Kombat and other games such as Doom and, what is it called? Night Trap were creating a desensitization to violence. In fact, it spurned a ton of studies on video game violence. Unfortunately for those against violent video games, the true scientific data that has come out has shown that playing violent video games does not actually lead to violent tendencies. Whereas a lot of people like to cite all of the statistics that supposedly state that playing violent video games leads to, increased aggression, increased dehumanization, increase in the findings that individuals see others as lacking core human qualities such as warmth, open-mindedness, and intelligence. While people like to cite these cases, at the same time, once you actually look through the study, you realize that there are some very large flaws in the way that the case was studied, in the results, and in fact, they might even be taking a small subset of that data to support their information. However, that is a different topic. I might explain how you can use statistics and things to lie about things very easily. That's not today. Today we are examining Brown versus the Entertainment Merchants Association. So, at the first court level, which is the District Court of California, they ruled in favor of the plaintiffs, which was the, Entertainment Merchants Association, finding that, the sale of the violent video games, was not something that could be, banned by California. On appeal by California, the Court of Appeal also upheld the exact same finding, and they
time for some fun.
Further expanded by saying that violent video games do not constitute obscenity under the First Amendment. Now, to be able to fully explain what's going on, I need to define obscenity for you, because under the First Amendment, as some may know, some may not know, the First Amendment protects your freedom of speech. Now, the big debate for a lot of people has always been, where is the freedom of speech stop that allow, government to regulate? Because you have to remember, the amendments stop the federal government and state governments from enacting laws to restrict your freedom, which is a freedom of speech. Now, within that, obscenity is one of the things that the court has held does not constitute free speech, as if it is obscene, the government has a duty to censor or, protect the people from it. Now, Obscenity laws are concerned with prohibiting lewd, filthy, or disgusting words or pictures. Indecent materials or depictions, normally speech or artistic expressions, for instance, well, speech is obviously what I'm doing right now, speaking. However, artistic expression is the one that is usually most up for grabs, such as movies, books, video games. Those types of things are considered artistic expression, as it is not necessarily direct speech where, like, I'm talking. It's more of the depiction of other things. So the question is, you know, where does that play in? So the government has held that while obscenity is unprotected, however, it does not mean it's a blanket, you know, feel free to do whatever you want to stop it. It has to be restricted in terms of a time, place, and manner. As in, you can't say, you can never have this video game out forever. Because that, you know, that's an overbroad law, and it would restrict a ton in chill speech, which is the one thing that they're most worried about. So, like, for instance, something you don't see around these days are porno theaters. It's a movie theater legitimately there to play porn. The government is allowed to restrict it as it is considered obscene. And it's restricted with time, place, and manner, as in it's not something that should be during the day used to play. The place, they can limit it to, say, you know, downtown, or no, you know, away, certain distance away from, like, schools or daycares. And, like, the manner can't be like, oh, you can never do this. It, you know, it's gotta be like, you know, be a nondescript building, don't, like, make it blatantly obvious it's a porn theater, that type of thing. Now, like, how does a court determine what is obscene? As obscenity is generally a objective test. As in, what I consider obscene might not necessarily be what Johnny down the street thinks is obscene. So the court established a standard that tests for obscenity through 3 tests. They look at whether the average person applying the community standard would find the work, speech, you know, art, when taken as a whole, if it appeals to a prurient interest. Jeez. Now, a prurient interest is a morbid, degrading, and unhealthy interest in sex, as opposed to, you know, just a candid interest, as in, like, you know, you're not obsessed with it. So basically, it's one of those, you can't be like, oh, this movie, there's a sex scene, all of a sudden it's like, this is obscene. It's like, there's one sex scene that takes up like a minute out of a 2-hour movie. That wouldn't be considered obscene, because when you take the entire motion picture as a whole, it's just a small little thing. But that's just step 1. Step 2 is whether the work depicts or describes in a patently offensive way sexual conduct specifically defined by the applicable state law. So basically, does the work, like, go overboard and consider it to be super, you know, yeah. And then finally, the third is whether the work, when taken as a whole, lacks serious literary, artistic, political, or scientific value. Basically, does it add something? So, yeah. Now that we've defined what obscenity is, going back to Brown. So, the court found that violent video games do not consider obscenity under the First Amendment. The second one is that the state does not have a compelling interest in preventing psychological or neurological harm to minors allegedly caused by video games. And 3, that even if the state had a compelling interest, the law was not narrowly tailored enough to meet that objective. Which leads us to another aspect of the law that I will be going into more detail later, which is that depending on the
You will remember my sting.
depending on what the government is trying to handle, they have different oh, what's the best word for it? They have to meet different thresholds in order to say that the law that they are applying is applicable. In this case, when restricting a fundamental right, freedom of speech, they have a stricter rule. It's called strict scrutiny, under which there must be a compelling state interest, and the law has to be narrowly tailored to take care of that interest, period. So, looking back at the enacted law, it imposed restrictions and labeling requirements on the sale or rental of violent video games to minors. Now, to narrowly tailor something, it needs to affect no more than necessary. So, just examining this restriction and labeling requirement on the sale or rental of violent video games to minors. That doesn't... Like, what is a violent video game at that point? Like, looking at Mortal Kombat, as I'm sure you have seen, it can get excessive, sure. But what about a game where, you know, there's just like one punch thrown occasionally? Is that an excessive, is that a violent video game? Well, who knows? It's not narrowly tailored. And then, this was, again, appealed by California because the appellate court affirmed the trial court, district court, which meant that they brought it up to the Supreme Court. Now, the Supreme Court doesn't take every court case that comes to them. They decide, and generally it has to be something that's very important, you know, hasn't been brought before. Video games, brand new. And the real thing that really brought this, like, forward is the fact that this video game broke the boundaries of what video games had been before. You know, like, there might have been a little blood here and there, but this was gore. This was the first time where it's like, you know, excessive violence was rewarded. So this was something that had never been there before. Thus, the Supreme Court needed to address it. Supreme Court needed to look at it. And then the late Antonin Scalia, who is by far the biggest on upholding your freedom of speech, is a huge Catholic and Republican, defended violent video games, which is the one redeeming factor for him. I have other reasons not to like him, but he said, like the protected books, plays, and movies that preceded them, video games communicate ideas, or even social messages, through many familiar literary devices such as characters, dialogue, plot, and music, and through features distinctive to the medium, such as the player's interaction with the virtual world. This suffices to confer First Amendment protection. Essentially, what he is saying is, just because you are controlling the character, just because you are creating these actions, doesn't mean that the video games don't have a story. They don't have a cause, a right. They don't convey a message. It's one of those, this is a brand new technology, but it is doing what we have done before with books and movies, except for it's in the player's hands. They are crafting the story in essence. So, that is why the Supreme Court had to play Mortal Kombat. These are 50, 60, 70, 80-year-old individuals playing Mortal Kombat and determining if if it has some value to society. And in the end, even with all this gore and violence you have been watching me, perpetuate, they have found that it's good. While not necessarily the best, it is good. However, we will go more into this, I don't know if it'll be next week or later, but because of this lawsuit, all the video game companies basically got together and created the ESRB, the Entertainment Software Rating Board, as a way to deter future issues with violent video games. But again, that is something that we will hit probably next week because that's pretty important to discuss. As well as we will probably hit more freedom of speech so that you understand this more. So, this was a lot more long-winded than I thought. I kind of just sat down, had my research in front of me, just kind of started talking. If you have any more questions, I can do a follow-up video on this later. I can answer questions down below. But, yeah, like I said, this is what I want to do. I want to explain the law to you. I want to help answer questions that you may have. And so, I hope you all are enjoying this so far. Like I said, this ran a lot longer than I thought it would. I probably missed a lot. I will do more if you guys want more. But until then, everybody, this has been this week's commentary. So until the next time, everybody, this is the Gaming Lawyer signing off for the week. Have a good week, everybody.
Need a moment?
Kenshi.